Good afternoon, everybody. Thank you for attending today's session on the VAWA. Just a couple things before we get started. Please keep your microphones and cameras off during the presentation to help limit distractions. Also, if you have questions, please type them in the chat box and I will relay them to our presenters as we go along. And lastly, if you need a certificate of completion, please email Stacy and she will get that sent out to you. And one more thing, at the end of today's presentation, there will be a survey sent out to everybody. Please take a couple minutes and fill that out and provide any feedback along with any possible topic ideas that you would like to see presented on. We do have a couple dates open for topics this go around, so any ideas, send them our way. So with that, I will turn it over to Darrianne and Heather.
Good afternoon. It looks like I'm not looking at you, but I really am. So let me move myself over. There we go. I am Darrianne Johnson, and I am the director of the Domestic Violence Center in Dickinson, North Dakota. And I will be co-presenting with Heather once she tells me how to get
My name is Heather Ingman. I am a case manager here with domestic violence. So we were invited again to give you guys some information on VAWA in regards to working with landlords and what that looks like. I will preface this by saying I am by no means an expert in this area. It's just something that we happen to do and have done for many, many years here. So the information that we will give you is information that is readily accessible, and we'll give you guys that information as well after. If you guys want links or documents that we've shared, you absolutely can have those. And yeah, most of it's just experience that we've had. And so I know working with landlords is not always the easiest, and it's definitely even more convoluted when you throw in the mix of violence and you throw in VAWA into that. So as Kylie said, if you have questions as they come up, feel free to type them in the chat and they will kind of help moderate with them. So.
And just so you know, we are going to read everything word for word. So if you need to get your blanket and a pillow, feel free to do that now. Just kidding, we won't. We will give you the, you got control of it. I will give you the definition of VAWA, however. The Violence Against Women's Act is a federal law that in part provides housing protections for people applying for or living in units subsidized by the federal government who have experienced domestic violence, dating violence, sexual assault, or stalking to help keep them safe and reduce their likelihood of experiencing homelessness.
So the reason why the VAWA is kind of broken apart and in its true definition here shows in part is because the VAWA Act is actually a very, very large federal act, and housing is only a piece of that act, which is what we're going to focus on here today. So specifically for the context of housing, that's why this piece of the definition was pulled and not the entire large document itself. So the biggest thing is that who does it cover? So it's going to, we're going to look at a couple different pieces of it. So we're going to look at who does it cover as far as individuals when you're talking about victims and survivors. And then we'll look at briefly who, as far as agencies, as far as landlords, does it cover, because it actually does not cover everybody. As far as private versus federally funded housing agencies. So when you look at domestic violence, it talks about who it covers as far as domestic violence, dating violence, stalking pieces of it. And so the caveat to all of this is that VAWA is a federal act, which trumps state. However, most landlords, most housing providers that you work with are not aware of that piece. And so a lot of them are going to defer back to what the state covers. And so we're going to talk a little bit what that difference looks like. And so for domestic violence specifically, when you talk about a current or former spouse, for domestic violence as a whole, you have to prove that domestic piece. When you're working with anything in regards to victim services, victim coverage, you have to prove that there is a domestic piece to it before you can actually prove the violence. And so when you look at what that domestic piece looks like, it can look like a current or former spouse. And that could mean that you're living with that person, not living with that person. Doesn't necessarily have to be that, but you have to have that relationship. It could mean a parent of a child in common. So you have a child with somebody and that's the only relationship that's there. The other piece of it is that it could be somebody that you are living with. And with that, it could mean similar to the current or former spouse, it could mean that you are married to that person or not married to that person. And so the protected persons want to talk a little bit about this just because it's not always clear on what that protected person could look like. And so when you look at the North Dakota definition, and for those of you that haven't looked at the state statute in reference to domestic violence, I would highly encourage you to do so. There's a lot of really good information in that, but for the sake of just giving you that information here, North Dakota defines a family or household member, which in reference to VAWA, this is where it fits in. It's that same person, same definition. It could mean a spouse, a family member, a former spouse, a parent, a child, persons related by blood or marriage, persons who are in a dating relationship, persons who are presently residing together or who have resided together in the past, persons who have a child in common, regardless of whether they are or have been married or have lived together at any time. And for the purpose of that, I'm going to tell you that a lot of times people look at the domestic relationship and they automatically assume a dating relationship, which is not necessarily true. So it could be a roommate situation where a violent scenario could have ensued. And so just to kind of throw that out there is that it doesn't always have to be an intimate relationship by any means. For the dating violence piece of it, and we'll kind of talk a little bit about this further down the slideshow here, but when you look at the VAWA definition, it's a little tricky in the fact that they look at what the length of relationship is, what the type of relationship is, and what the frequency of interactions between the persons are. And so that's where I'll tell you that there's a big discrepancy between what North Dakota considers dating violence and what the federal government determines as dating violence. The other thing that I want to throw out there is that dating violence and domestic violence, for those of you that don't work in a victim service profession, is that they're oftentimes used interchangeably. So a lot of times when you hear dating violence, you'll hear somebody refer to it as domestic violence or vice versa. The other thing to know about dating violence is that oftentimes you will hear it similarly in conversation when you talk about teen dating violence, because that's oftentimes the terminology that's used when you are working with a younger population. But just so you know, those terms are, there are different definitions for both, but they oftentimes are used interchangeably between the two. Sexual assault and stalking are the two other areas that it specifically talks to in regards to VAWA. And so sexual assault at its core is any non-consensual sexual act, whether it's forcible rape, whether it's groping, whether it's digital penetration, whether it's cyber sexting, you name it, any non-consensual act falls into that sexual act piece. And I want to talk a little bit about includes when a victim cannot consent. So we see that in a few different pieces here. So the first and foremost, when people think about non-consent, they think about people who are under the influence, which absolutely is a true statement. When somebody's under the influence of drugs or alcohol, they obviously cannot consent if they are not aware of what is going on. But the other big piece that is relevant when you talk about housing specifically is that a lot of times you see people with guardians. And so when you talk about maybe somebody who is incapacitated because intellectually they don't have the ability to make decisions for themselves and they have a guardian at place, or I'm trying to think, we've seen it when we've had elderly people who have a guardian that's making decisions for them. And so it doesn't always have to be the inability to consent because they were under the influence of drugs or alcohol. There's a variety of reasons. So just want to kind of throw that out there for you. And then when you look at stalking, so stalking by nature is one of the hardest crimes to prove just because it takes a substantial amount of evidence to put into place for stalking. But when you look at housing providers, there's a big piece, and landlords can play a big piece in this. And you'll hear us talk quite a bit about what that relationship looks like between victims and survivors and landlords, and victims and survivors that are renting in specific properties. But we'll also talk about what that relationship looks like advocating for those victims and survivors from your own agencies. And so landlords can play a really big piece in that if they are willing to assist a victim with gathering evidence. And so what that may look like in a very simplistic form is willing to replay video footage. So Sally comes to your office and you're a landlord and says that John broke into my vehicle last night and he continually drove around the property 50 plus times. Okay. So we sit down with Sally and we say, we're going to try and replay that evidence to see what we can help gather. And so really, really advocating for that victim, and that you're gonna need those hard evidence, those hard pieces, more so than just saying, John drove around my unit 50 plus times last night. So anything that a landlord is willing to do to assist a victim with that, just know that by nature, stalking is one of the hardest things to prove in the victim service field. Sorry, guys. So housing coverage, when you talk about VAWA, and I think this is a question that we get quite regularly, is that who does VAWA cover? And so when you're talking about survivors, when you're talking about victims, when you're talking about the vast majority of individuals that probably most of us serve, they're in HUD-funded properties. They're in low-income properties that receive some sort of federal assistance. And so they are not necessarily in the private landlord sector. I can't really say often, because there are times where that is the case due to backgrounds, due to rental history, where a private landlord, where that's going to be the only option. But just to make note that was going to cover these properties here. So they're going to cover public housing that falls under HUD funding. They're going to cover the Section 8 choice voucher, supportive housing for elderly, supportive housing for persons with disabilities. They're going to cover the multifamily, the BMIR, the home programs, the HOPWA programs, the McKinney-Vento programs. Most of the programs that I'm assuming, again, the vast majority who is on this call fall under those categories. The other ones that they're going to cover under the USDA is specifically under the Rural Development and Multifamily Housing Program. So the section, the 515, the 514, 516s. And I didn't specifically go out and list all of these just because they are unique to different agencies and who they serve. But just so you know, it falls under federal assistance programs as far as housing goes. So it doesn't fall under the private sector, which again, we'll talk a little bit about. I have some examples, and I have some state law that kind of pulls, but just so you know, it does not fall under private landlord, private tenants.
Okay, the protections that are afforded are: you cannot be denied admission or assistance, cannot be evicted or have your assistance terminated, cannot be denied due to violence or abuse. Option to stay in housing for safety reasons, must be able to keep assistance if there is a housing voucher. Self-certify abuse using a HUD form. Heather will show you a copy of one of those so that you can see what it looks like. Unless conflicting information is part of the situation, then you won't be able to use that form. Lease bifurcation from owner of the property to remove the offender from the lease, and cannot be coerced, intimidated, threatened, or retaliated against by housing providers.
So on the self-certifying abuse, unless conflicting information, so most of the time somebody can self-certify either by themselves and or with assistance from a variety of different entities. But I will say is that when you talk about conflicting information, and so I don't know if we have any law enforcement individuals on the call here, but I will say is that we are seeing more and more in that law enforcement is having a harder time to differentiate who the primary aggressor is. And so they're making dual arrests, which again, when you're talking about victim protections, when you're talking about VAWA, and you're talking about landlords, that becomes pretty difficult when you're trying to say, okay, I believe that this person is the primary aggressor or this person is the victim. And I say that we know that even as a victim service provider, that it becomes an overwhelmingly daunting task, especially when you talk about the rate at which victims go back to an offender or back to an environment that is not safe or not healthy. On average, that's 7 times. And I would say that's probably a pretty outdated statistic in that we see people go back more often than that. But so when you talk about a landlord, and I kind of throw this out there in that even as a victim service provider, I will say that advocating for a survivor, advocating for a victim, oftentimes requires you to have a little bit of grace on the people that you're advocating against, in that when you think about a landlord having to call law enforcement over and over and over again, and a victim remaining in that situation, it becomes very overwhelming. It becomes very frustrating for a landlord. And these are all conversations that we've had. And it comes back to some education in that, you know, a victim isn't going to leave the first time more often than not. And you're going to see that person there, and you're probably going to have to call law enforcement time and time again. And really just having that conversation on what does it look like? How do we work through those situations? And part of that is bringing VAWA into it. And part of that is notifying them what their rights are, what protections even as a landlord they have. You know, when you look at HUD at its core, HUD's recommendation isn't to do an automatic eviction. HUD's recommendation is to say as a last resort, then you may proceed with an eviction. Now, obviously, if there's, safety concerns in place, those need to be taken seriously. And again, that's that education piece with landlord, but truly just have some grace when working with landlords. And I say that as a victim service provider, advocating every single day for victims, is that not everybody understands your role, not everybody understands your mentality or where you're coming from. And sometimes taking a step back and putting yourself in their shoes and understanding that they're managing a lot of different properties and they are trying to keep a lot of different people safe, can kind of shed some light and build that rapport within that relationship. The other piece that I'll say to that is that they do have the right to remove the offender from the lease. Where that gets a little bit tricky again is when you're talking about federally funded properties versus non-federally funded properties. And we'll talk a little bit about what that looks like in just a little bit here. The other thing that I want to throw out that I feel like we as service providers oftentimes have to have a conversation with, and it's an education piece with landlords, is that if there is a charge of domestic violence or stalking or sexual assault or something that is violent in nature to somebody in the property, a lot of times they want to do an immediate eviction for everybody in the property. Again, that's a protection under VAWA, that if you are a victim of violence, you cannot be held accountable, or you cannot be held responsible for somebody else's actions if you are directly the victim to the crime. And you also cannot be held responsible for repeated offenses of that offender, which again, when you talk about law enforcement being called numerous times to different properties, that piece kind of plays in there. So when you talk about proving the abuse, what does that look like? How do you prove it? How do you show a landlord that there is in fact a reason why I should not be in this property anymore? A big piece of it, so housing providers, they may but are not required to, and in my experience, they seem to go more on the may, and they do want that documentation. And I guess I have not had a conversation with a housing provider as to why. I can make assumptions as to why. But nonetheless, they may but are not required to ask for documentation if VAWA protections are asserted. So a lot of times they're going to ask for a police report, they're going to ask for a protection order, they're going to ask for something from a victim services provider, but they don't have to do that. They may take the victim's word. If the documentation is requested, it must be made in writing. So the landlord has to provide to the victim, to the tenant, that they need that documentation, and it has to be done in writing. And then the victim has 14 business days to provide that documentation. Now, the landlord does have the right to extend that 14 days if, for whatever reason, a victim cannot obtain that documentation. And so where that might come into play is, for instance, for those of you that are familiar with a protective order, be it a restraining order, domestic violence protection order, by law, if somebody goes in and requests a protection order and it is granted, the court legally has to set a hearing date within 14 days. And so we have landlords that are saying that we would abide by it for those 14 days, and then at a permanent hearing, we would make a different decision. And so sometimes they'll say within that 14-day period, we may have to extend it based on a hearing date or based on any criminal proceedings. We've seen that played out before. But I will say in that, when we talked just a little bit ago about building a rapport with landlords, I cannot tell you how important those pieces are, because when you build those relationships, you have better cooperation. When you can not only vouch to a victim for the relationship that you have with a landlord, it goes a really long way. But even more so when you say that you have this case, you have this situation, and a landlord saying, I believe you came through last time, you were able to get me, XYZ documents. Building those relationships are extremely instrumental, especially when you are working with a victim of a violent crime, just because you don't always get the most transparency. And I say that as a victim provider. Victims are scared for a lot of reasons. Survivors are scared for a lot of reasons, and you might not get the exact story right off the bat. And that's where those relationship pieces come into play. And I will, again, I have an example of the self-certification that I'll show you at the very end here, but there's a reason why victims don't give you the truth. And a lot of times that filters over to their housing provider, that filters over into a landlord, and it can be anything from financial abuse. It can be threats of life. It can be threats of taking a kid and run. I mean, you name it, and your victim service providers have probably heard it. The other thing that I'll tell you with the verification is that if you have not already built your relationship with your DV or sexual assault providers in your jurisdiction, I would highly, highly encourage it. Not that we're any better at advocating than anybody else, just that we are oftentimes more familiar with documents. We're more familiar with paperwork. We're more familiar with when it comes to a victim of a crime. And so building those relationships, you can oftentimes get the documents that you need pretty regularly, and not having to necessarily rely on the victim to gather those documents, because that's not always an easy task. You know, when you think about your own life, your own situation, and when you're faced with chaos, you're not thinking straight, you're not thinking in the moment. And so having that outside help is invaluable in a lot of scenarios. And so I really, really encourage you, if you haven't built that relationship, built that rapport with your DV agencies in your area, to definitely do that. So when you talk about the documentation, so HUD itself provides, and they give resources, and I will give you guys those links. But they do a good job, I will say, at providing kind of a black and white documentation of what that looks like. My presenter just abandoned me, I guess. They provide documentation of what that looks like, and again, I have some examples for you. But they're pretty easy to fill out. So the first one being an approved certification form. And so that is a lot of times what we will use when you talk about assisting a victim in getting out of housing, getting back to safety, getting an offender off the lease. That simple self-certification form is pretty black and white. It asks, you know, who they are, what the address is, who the offender is, who else is on the lease. Again, pretty simplistic to fill out. Those documentations, those self-certification forms, when I said that there are individuals that can assist the victim in doing that, signed by the victim, can be signed by a service provider, an attorney, a medical professional, mental health professional, really anybody that can vouch for the abuse that has taken place. However, I will tell you, so your domestic violence sexual assault advocates are protected. And so the only way that most agencies are going to turn over any type of information is going to be through a subpoena. And most of your BVSA, the SA agencies are going to fight the subpoenas that come in. And so when you talk about a mental health professional, when documents are requested, sometimes they're not the best of documents. Sometimes you have somebody who would have disclosed that they had an addiction that they were active in, and the adjoining party would get a hold of that and say, well, they just admitted to a therapist that they have an addiction, so why am I going to let them around my kids? And so when I say that sometimes it's easier just to have the victim service provider assist in that, it will limit the request for further documents down the road. And so I know in the immediate, we're talking about housing, we're talking the forefront of what's in front of us, but I will tell you that sometimes you have to look beyond that scope, and to say that if a victim or survivor accesses services and down the road you're now being subpoenaed, or your documents are being requested for a divorce or custody or medical, you name it, and those documents that come back to hurt somebody, well, then when you look back 2 years ago when you were trying to help somebody with the simple basis of housing, it could have come back to hurt them. And so just be aware that advocates are protected in a lot of ways. And again, sometimes it's easier just to pull that card than to have to say, I'm going to find an officer, I'm going to find an attorney, I'm going to find a medical professional to try to self-certify this form. When you have, and again, building those relationships with your local agencies are important. So federal, state, tribal, territorial, or local police, court, or administrative record, those are all accessible documents. Those are all documentation that would suffice to prove that there was an incident of domestic violence, an incident of abuse that's taken place. Conflicting information is provided to the housing provider. Third-party documentation may be requested. And so it's not often, I will say, that third-party documentation is requested, but it is definitely a piece that a housing provider or landlord can come back and say that they need, and that the HUD forms that were provided were not sufficient. And what that may look like is when you have, again, that dual combative relationship, or somebody coming in with self-defense, and now you have two different arrest records, and now you're saying, well, Sally was the one that was arrested for domestic violence, but John was also arrested for domestic violence, and now you have a landlord trying to decipher what happened, who did it, who was the primary, who's the actual victim, are they both victims, are they both aggressors? So that third-party documentation may be requested, and that may look like extra police reports, that may look like court documents, that may look like protection orders. I mean, you can think about anything that would aid in assisting somebody to determine right from wrong, who was the aggressor, who wasn't the aggressor. And so, yeah, just know that it's not often that third-party documentation may be requested, but there are occasions where it is requested. And again, sometimes as an agency, that's stuff that we'll help gather. And sometimes you have a landlord saying that they're going to do it themselves. They'll gather the necessary documents, which again, as long as they're doing it correctly, that there's no harm in doing that. So I'm going to talk a little bit about this piece here. So actual or imminent threat. And so there are two different definitions that we need to look at. And I'm going to explain to you why this is important. So the HUD's definition of imminent threat is physical danger that is real, would occur within an immediate time frame, and could result in death or serious bodily harm. Now, VAWA in and of itself does not have a definition of what imminent threat is. So HUD brings in the piece where they list their definition. Now, when you look at the ND Century Code, there is nowhere where imminent is directly defined. However, it is listed. So in part of the domestic violence statute, it says domestic violence includes physical harm, bodily injury, sexual activity compelled by physical force, assault, or the infliction of fear or imminent physical harm. Now, where this gets very, very complicated and very, very convoluted, and not just our everyday work with domestic violence victims, with sexual assault victims, with victims of violence, but when you take into this perspective, not everybody's imminent is going to be the same. Darrianne's imminent might be 2 weeks ago. My imminent might be 2 years ago. But to me, that threat is real. To me, that threat of danger could be very real depending on the circumstances. It could be real depending on how I was raised. It could be real depending on what I've experienced in my adult life. So when you take two survivors, two victims side by side, imminent can mean two very, very different things. And so when you're trying to articulate to somebody, specifically a housing provider, what that imminent looks like, you have to be very cognizant of the fact that even a housing provider's rationale of what imminent might be very different than what that survivor is. And it's really important to help that survivor, help that victim to articulate what imminent really means to them and why it means what it means. And so I'll give you for instance, I was working with a victim and we had submitted a protection order to the court, and I sat in the judge's chambers and he said, I'm not going to sign this order. And I had asked why, and there was pretty significant threat and fear of domestic violence in that order. And he flat out, the judicial officer looked at me and said, just because I shake my fist in your face doesn't mean that I'm going to hit you. And I said, with all due respect, you are correct. Just because I shake my fist. Yeah. Oh, just kidding. You know, just because I shake my fist doesn't mean that I'm going to hit you. And absolutely, that is the case. Just because I shake my fist in your face does not mean that I'm going to hit you. However, every other incident of where that person had committed domestic violence had inflicted that fear, that imminent threat that something was going to happen when that fist was shaken in this victim's face. And so just taking a look at what imminent really, really means, especially articulating to a landlord, right? Because again, you could have a victim sitting there saying that, you know, I'm fearful that he's going to come and do X, Y, Z. And you could have a landlord saying, well, when was the last time that happened? Why do you feel that that is a threat? Why do you feel like those circumstances could arise? And that victim is saying, well, he hasn't done it in 2 years. Well, if you're not asking the right questions, 2 years could mean because that person was in jail for aggravated assault. Well, yeah, in 2 years, I felt safe because I knew that he was behind bars or because she was behind bars. So really, really important to get the full picture and being able to relay that full picture to a landlord, to a property manager. But again, just being aware that we all kind of walk into everything with our own definition. We walk into it, depending on life circumstances, depending on what's been done to us, and really being able to articulate to those that we are working with. So eviction of an abuser, we talked about that they do have the right to evict an abuser. The big piece of that is that a lot of times they as in housing providers, they as in landlords are under the impression that if one party goes off of the lease, then all parties have to go off of the lease, which is not the case. A victim under VAWA has the right to remain on that lease. Have the right to remain with the assistance that they're on, even if an offender is kicked off of that lease. The other piece of that is that not often, but there are times where you have a victim who is residing in a unit who may not be on a lease, but may be authorized to stay there. And so if that's the case, that victim does have the right to remain there, regardless of if the offender is evicted or not. And then a landlord under VAWA has to work with that victim within reasonable means to be able to keep that victim housed there, whether that's allowing them time to apply for their own public assistance, whether that's allowing them to find a different job or the means to be able to pay for the unit that they're in, because that's not always the case that the victim's able to really pay for it as well. But eviction of an abuser via a tenant or via a landlord can be done, especially if a safety concern is at place. But also they are aware of federal, state, and local laws when doing so, because sometimes they are conflicting, and again, they don't always know the laws that are in front of them. And so again, HUD does a really good job at providing the federal side of things, and then looking further into what the state actually says, what can and can't be done is also equally important. So non-VAWA protections. So we've talked a lot about housing and what that looks like when they are federally funded. And I will tell you that we have gone round and round and round with landlords because they are not HUD funded. They are not federally funded by any means. And they're saying, well, we don't have to comply with VAWA. That's true. You're right. You don't have to comply with VAWA. However, North Dakota does have protections in place that are not directly related to VAWA, that I would say are really important when you are challenging the ability to keep a victim safe, whether that means remaining in a unit or helping them transition out of a unit into a different unit. So I did list the Century Code, and it is, this is just a piece off of the 47-16. This is specific into the 17.1, the termination due to domestic abuse. And so no self-certification, meaning that when you look at VAWA, that was an option. I could use one of the HUD-funded forms to say that I'm a victim of violence, and I can verify it by saying, a service provider can help me. I have the law enforcement police report. I have this court document. So under the North Dakota law, they do not allow a self-certification. There has to be three different pieces that have to be displayed to a landlord. And so the first being that the tenant fears imminent, and again, there where you see that imminent, what is imminent to every individual is going to be unique. But there has to be that the tenant fears imminent domestic violence from a person named in a court order, protection order under the North Dakota, that's the North Dakota Century Code, an ex parte temporary protection order, and that's that order that's good for within a 14-day period prior to a permanent hearing date. Even if that permanent hearing date gets extended for whatever reason, that ex parte order does stay in place. Or an order prohibiting contact, restraining order, or other record filed with a court. Has to be something in place. And so there has to be some legal document saying that a person cannot be within so many feet of another individual. And usually I can say, I'm trying to think if I've ever had an order not list an address or a residence unless it was a safety concern. But usually there's an address listed on there, which then would give the landlord the verification that they need to say this person cannot be at this address. So that's where that kind of court piece comes into play. But then the tenant also needs to that there has to be in writing the tenant needs to terminate the tenancy and then the specific date that the tenant will terminate. Now I will tell you, I did not list this full century code on here, but there are very specific pieces to this as far as how long a tenant has to continually pay rent, or if it's in the middle of a rental period. But what this piece does is it does allow somebody out of the lease earlier than what a lease agreement would state, which is oftentimes the issue. But just to know that there is a difference between what VAWA protects and then what non-VAWA programs will accept as documentation. So just to know that there is a difference in that, especially when you're working with a victim, it's important to know that, or to know which type of agency they are housed in, just so you know which documents that you need to gather. And then the HUD VAWA forms here. So the self-certification form is the first and foremost. That's probably the easiest, and I will say it's what we use often. I can't say it's what we always use, but it is the form that we use most readily, just because in its base form, it's pretty simplistic to fill out. Even if somebody in the middle of chaos was trying to do it on their own, it's pretty easy to understand. And then, so the couple HUD approved forms, and there are more than these, but I will tell you, these are the ones that are used most often. The HUD form 5383 is the certification form that would prove domestic violence or abuse or sexual assault or stalking. That's the document that HUD provides that says landlords have to accept. It is a HUD acceptable form. And then the other one is an emergency transfer plan. And so I know that we didn't talk a whole lot about that, but under VAWA, a victim of violence in a HUD funded and federally funded program has the right to transfer. And where this really comes into play is if there's a voucher attached to it. For those of you that have worked with vouchers, it's not always the easiest or doable to transfer vouchers from one area to the other, especially even if it's just from county to county. But under VAWA protections, a victim of a violent act has that right to do that. But there are forms, HUD does provide those forms in order to make that kind of clean for both parties, for both ends. So I did show, and I took out the victim's information, but so this was an example of just a self-certification form that I assisted a victim in completing. And so what makes this form unique is that, so in your own words, and so this was written both by myself and the victim who was exiting out of housing. So she was a victim of domestic violence along with her 4 children. And then she put that he was assaulting her oldest son, and then he tried to come after her. So in her defense, she fired a weapon in self-defense and called the police. The police helped me and my children leave for our safety. So when you talk about that there are circumstances where you would have both people listed as an aggressor. So you have a mom of 4 kids who is calling law enforcement, who is saying, you know, my husband is threatening me. My husband has assaulted me. He went after one of my children. And then you have the husband on the other line. When law enforcement gets there, the husband saying, well, wait a minute, she just fired a gun at me. Like, my life is in danger. I feel threatened. Then you have, again, a landlord saying, now I need more information. This has gone far beyond, you know, a mom of 4 kids saying that she's in danger, she's being assaulted, to now I have 2 parties saying they're both in danger, both were assaulted. So then when she states here that police helped her and her children leave for safety, that third party information that was obtained right on the scene from law enforcement. Law enforcement did a great job on this one, and it's not always in black and white, I will say that. But law enforcement was able to paint the picture for the landlord to say that, again, there's a history of domestic violence. This is the first time that we've been here. These are the charges that have been placed. There are criminal charges pending. You know, law enforcement was able to kind of fill in the gap, paint the picture. But again, a landlord wasn't able to just take a victim survivor's word right in that moment, just because there were extenuating circumstances. So I shared this form here just for a couple of reasons. You can see it is very easy to fill out. Again, I blocked out the identifying information, but they just need a simple description of what happened. And as long as there's, again, no other extenuating circumstances, this usually suffice for a landlord. Again, this was a HUD form that was used. Landlords were familiar with it, and if they weren't familiar with it, they were willing to kind of hear what was going on. So again, I shared this just because it was a very unique situation, and it kind of showed that there was that extra piece, that extra third-party information, which we don't always necessarily see. So I think that is all I have on my end, and we're not too far off from time, but if there are any questions I can help answer, I would be happy to do so. I will just share here just so you guys can see. Here is that emergency transfer and the domestic violence certification. So as you can see, it is a pretty simplistic form. It gives a really good description of what is defined under HUD's definition and how under VAWA it's protected. You can see here that right at the base there, they say the Violence Against Women Act, and then what the purpose of the form is. So there is this form here, and then I will also show you. This is one of the emergency transfer plans. Again, here another form, and you have the ability here to fill in the necessary information. This is kind of just a blank copy. This is all accessible on a HUD website that's downloadable. You can fill it out that you're able to assist the victim with. But again, HUD doesn't always make things the easiest, as most of you on the call here know, but I will say in this regard, they've done a really good job, especially when it comes to a victim and needs of the victim. And I will show you. So here, HUD does a really good job at displaying on their website information. You can also get the forms on this website as well, but they do give updated information on what's new and what's going on with VAWA. They do also, which is very helpful, you know, if you want some light nighttime reading, they give some VAWA cases here, which kind of give an idea of what's being contested, what's not being contested. Again, there's a nice section here for the forms that you can get, that you can aid to assist a victim with, but just wanted to, give you an idea. And then I will show you here, this is the actual statute for domestic violence, again, accessible if you just Google domestic violence, North Dakota statute. But again, it does give you some really good definitions of what North Dakota defines as domestic violence, who they define as a family or a household, gives you information on what the protection order process looks like, and what that all entails. And then, so here was the Century Code, the chapter 46-16, and it falls under the leasing of real property. And so that's where the pieces of if there was abuse in the home. So this would be where you would cite and refer to if you were in a non-federally funded property or working with a landlord that was in a non-federally funded property versus somebody who would fall under VAWA. With that, if you guys have any questions, then I'd be happy to answer them. If, yeah, if you have any.
Anyone have any questions for Darianne or Heather?
I have a question. Do you guys ever help men with this kind of stuff?
We do. Yep. So
Okay.
all of our services that we provide here, and I apologize, I probably should have prefaced that before we started here, but we serve men as well. The only thing as far as like our shelter goes is that we can't house men in our physical shelter, but yes, absolutely help men just as much as women. I also will add and that's a good question, Hillary, I thank you for that. The one thing that I will add is that they just updated the VAWA Act, and part of that update was to include the LGBTQ population because it was very limited in the previous version of VAWA. So I think that kind of adds to your question too, Hillary, is that, yeah, we do help a variety of people, to include men, to include members of the LGBTQ population. It's not just limited to women.
Thank you.
You bet.
All right, well, I'm not seeing any other questions. So thank you, ladies, again, for taking time out and presenting to us. Great information. Again, for those of you that are still on, please be on the lookout for that survey that should be sent here either today or tomorrow. Take a few minutes and fill it out. Again, if you need a certificate of completion, I'll email Stacy and she will get that sent out to you as well. So with that, I think we will wrap up for today. Next week, we have our presentation on sleep and self-care. So look forward to having you all back next week. Thank you.
Thanks, Kylie.